What happens if a judge has a conflict of interest? Have you ever wondered what occurs when a judge finds themselves in a situation where their personal or financial interests might interfere with their ability to be fair? This scenario is known as a conflict of interest. It can arise when a judge has a relationship with one of the parties involved in a case or has a financial stake in the outcome. When this happens, the judge must take specific actions to maintain the integrity of the judicial process. The most common response to a conflict of interest is recusal. This means the judge must step back from the case entirely. Recusal is essential to ensure that the judicial process remains fair and impartial. Judges are guided by strict codes of conduct that requiring them to avoid any situations that could be seen as biased. If a judge recognizes a significant conflict, they must disclose it and recuse themselves to maintain public trust in the justice system. If a judge fails to recuse themselves despite a known conflict, several things can happen. An affected party can file a motion to disqualify the judge, arguing that their impartiality is compromised. This can lead to an appeal of the judge's decisions based on perceived bias. In some cases, the court may decide to remand the case, meaning it will be sent back for a new trial or hearing with a different judge. Additionally, a judge who does not disclose a conflict may face disciplinary actions. These can range from censure to suspension or even removal from the bench, depending on the severity of the situation. Such failures can damage the credibility of the judicial system and lead to public skepticism about the fairness of the legal process. For those studying law, understanding conflicts of interest is vital. It highlights the importance of ethics in the judicial decision-making process. Law students learn that judges must not only apply the law but also remain neutral and avoid any conflicts that could affect their judgment. Judges are trained to recognize potential conflicts before and during cases. They often review their personal and financial interests to ensure they do not have any ties to the parties involved. If a conflict arises, they must act quickly to disclose it and recuse themselves if necessary. This practice is crucial for protecting the rights of all parties involved and upholding the integrity of the legal system. In short, when a judge has a conflict of interest, they are ethically required to disclose it and typically must recuse themselves from the case. Failing to do so can lead to legal challenges, disciplinary actions, and a loss of public confidence in the judicial system. Understanding these principles is a key part of legal education and is essential for anyone pursuing a career in law or considering judgeships and judicial appointments.